Mr. Cohn, I see you are in the courtroom. I see Mr. Conklin is in with audio. I don't see him yet, and there he is. Very good. All right, so Mr. Conklin, you are up.
Thank you, Your Honor. May it please the court, Leslie M. Conklin, and I represent Black Point Assets, Inc. as trustee. This case comes to the court on appeal from a final judgment of foreclosure and reestablishing a lost promissory note in favor of the appellee Bank of New York Mellon. In July of 2016, the original plaintiff in this case, National Residential Assets Corp., files a complaint for foreclosure and reestablishment of a lost promissory note. The copy of the note attached to the complaint contains no endorsement. In December of 2017, about a year and a half later, National Residential Assets moves to substitute Bank of New York Mellon as the party plaintiff. Attached to that motion was an assignment of mortgage from Bank of America, the original lender, not the original plaintiff, the original lender, to National Residential Assets, and a corrective corporate assignment of mortgage from the National Residential Assets to Bank of New York. And then subsequently, the court entered an order granting the amended motion for substitution of Bank of New York. However, this case really turns upon the statute, which is 673.3091, which deals with the reestablishment of lost promissory notes. It has three elements that you have to prove to do that. And without reestablishing the lost promissory note, you obviously also do not establish standing. And the most important of those three elements is the person seeking to enforce the instrument was entitled to enforce the instrument when loss of possession occurred, or is directly or indirectly acquired ownership of the instrument from a person who was entitled to the instrument when the loss of possession occurred. So the problem with this case is that there was a prior lawsuit in 2008 filed by the Bank of New York, and both in discovery by way of request for admissions, Bank of New York admits the prior case, that it was filed, and that at trial, the defendant also asked for judicial notice of the prior lawsuit. Filed with that demand for judicial notice was a certified copy of the complaint for the 2008 lawsuit. And in paragraph 4 of that complaint, Bank of New York alleged that it was, quote, the owner and holder of the subject note and mortgage. Ironically, or perhaps not ironically, the copy of the note attached to the 2008 complaint was identical to the copy of the promissory note attached to the 2016 complaint filed by National Residential Assets, has no endorsement or allonge to it.
That complaint wasn't verified, right?
I'm sorry?
That complaint wasn't verified?
No, the 2008 complaint, that was obviously prior to the change in the law that required it to be verified. But at trial, keep in mind that Bank of New York is relying upon two assignments of mortgage to establish their standing, and the fact that they obtained the note from somebody who had the note at the time of loss. And they're missing a key element. Bank of New York, the complaint may be unverified, but nonetheless, it's signed by the law firm which Bank of America sent the promissory note to Greenspoon Martyr to file the lawsuit. Greenspoon Martyr, in their testimony at trial, said, we never received the original note. So the complaint is for foreclosure and reestablishment of a lost note. But the complaint nonetheless signed by an attorney with Greenspoon Martyr on behalf of Bank of America states that the owner and holder, ironically at paragraph 4 of the 2008 complaint, says that they're the owners and holders of the promissory note and mortgage. And so the point is, the court basically disregards there's a missing piece of the puzzle. And that is, if you have to reestablish the promissory note by that I was entitled to possession from someone who had the note at the time of loss, the testimony was uncontroverted that promissory notes sent by Bank of America to Greenspoon Martyr for the purpose of Greenspoon Martyr filing a complaint on behalf of Bank of New York. So in the 2016 lawsuit filed by National Residential Assets, we're missing where is the assignment of mortgage from Bank of New York back to Bank of America for that first assignment of the note of mortgage. We're missing that piece. At the time of loss, the allegation in the complaint is that Bank of New York is the owner and holder of the note of mortgage, not Bank of America, the original lender. So the judge, in his findings and is certainly, emphasized in the answer brief, states, well, it's an unverified complaint. Attorneys make mistakes. Just the other day, I had a case where, it was wrong. But I'm not certain, how does the lower court elevate the validity of the an assignment of mortgage and a corrective assignment of mortgage over the complaint filed in 2008, signed by an attorney under the rules, promulgated by the Florida Bar, that every attorney, when you sign a pleading, has done an investigation as to the, underlying facts of the complaint. How do you elevate the two assignments of mortgage over the validity of the complaint alleging that at the time of loss, the owner and holder of the note of mortgage was Bank of New York, not Bank of America? Fine. In 2008, the law did not require complaints for foreclosure to be verified. But the two assignments of mortgage aren't sworn to. They're notarized under the requirement that they have to be notarized in order to be recorded in the public records. But if you review the two exhibits themselves, the two assignments of mortgage, they're not sworn to. And if the court had said, well, attorneys make mistakes all the time, and that the 2008 lawsuit, that could have been a mistake. It may not have been Bank of New York. Maybe it was somebody else. But if that's the case, at the upper left-hand corner of each of the two assignments of mortgage are prepared by law firms. How do we know that that wasn't a mistake? So, as I say, the trial court, in making its decision that standing was established and that evidence was sufficient to support the claim of to reestablish the lost promissory note, we're basically then completely ignoring that there was a prior lawsuit where Bank of New York alleged that it was the owner and holder of the promissory note of mortgage at the time that the note was lost. And we are missing then the key element, and that is, where does Bank of America get the authority to sign an assignment of note and mortgage to the original plaintiff, National Residential Assets, when there's no evidence that Bank of New York ever transferred the note and mortgage from it to Bank of America? That basically is the point of the case. I'd like to reserve 5 minutes for rebuttal.
Very good. Thank you, Mr. Conklin. Mr. Cohn?
Good afternoon, Your Honors. May it please the court, Joseph Cohn for the appellee, the Bank of New York Mellon. As you've heard, the sole issue in this case on appeal is standing. And the unrebutted evidence that was actually introduced, offered, and admitted at trial demonstrated a straightforward chain of transfers of the original note from the original lender, Bank of America, to the appellee, the Bank of New York Mellon. The Bank of America was the original lender under this 2005 loan, under the note and the mortgage. It was uncontested that they possessed the original note up until October 2008, which is when they sent it to their counsel, Greenspoon Martyr. And you heard that it was sent for the purpose of filing a complaint in the name of Bank of New York Mellon. There's no evidence of that. In fact, all of the evidence, we heard detailed evidence from Greenspoon Martyr and Bank of America based on their records and their testimony, establishing that Greenspoon Martyr's client was Bank of America. And so the note was lost in October 2008 when it was transferred from Bank of America, the owner of the loan at that time, to its client, Greenspoon Martyr. That evidence, again, was unrebutted below, and I don't believe it's contested on appeal that the note was in the possession of Bank of America and was lost. And then 3 years later, in 2011, which is 6 years after origination, Bank of America sells the loan to National Residential Assets Corp. You heard that there's no endorsements on the note. It would not have made any sense for there to be any endorsements. Unlike the vast majority of cases, this was not a loan that was securitized into a trust right after origination. That's when you see endorsements pursuant to, Article 3 and the requirements of pooling and servicing agreements. In this case, this was a whole loan maintained on Bank of America's books for the first 6 years of the loan. So Bank of America never would have endorsed its note in blank. When it sold the loan in 2011, it had already lost the note, so it couldn't have put any endorsements on it. So it did what it's supposed to do, what you would expect, which is to record an assignment of the note and mortgage to the new owner, National Residential Assets Corp. And then in 2016, the owner of the loan, National Residential, files this lawsuit. They were the owner at the time. They had acquired it directly from the party who was entitled to enforce the note at the time the note was lost. That was Bank of America, who was entitled to enforce the note in October 2008 as the party in possession of the loan, of the note. And then the following year, National Residential sold the loan to the current appellee, Bank of New York Mellon, who substituted in. Now, the evidence shows that those two transfers were the only two transfers that ever occurred. Those two transfers are on record pages 581 and 582. There's no conflicting evidence whatsoever on this straightforward chain of ownership. The only thing there was below, and there is on appeal, is an argument based on a request for judicial notice of an unverified complaint that was filed in 2008 in a separate lawsuit. That contained an unsworn, unproven allegation that Bank of New York was the holder and owner of the loan. That complaint was dismissed for lack of prosecution. That allegation was never proven in that case. And that complaint and that allegation was never offered or admitted into evidence in this case. And yet that unsworn, unproven hearsay allegation is, again, the sole basis for the defense and the sole basis for this appeal. Even though Bank of New York Mellon was, of course, the predecessor to the Bank of New York, or excuse me, the other way around, Bank of New York was the predecessor to the Bank of New York Mellon. And so ultimately all, roads lead to the same plaintiff. There is zero evidence that anyone other than Bank of America owned the loan in 2008. And the trial judge did explain this. He explained that, yes, he was taking judicial notice of the existence of that complaint. But he also explained that the allegation itself was not evidence or proof of anything. And instead, he properly relied on the actual evidence that was before him, which, again, documented this unbroken chain of transfers from the original lender to Bank of New York Mellon. And under 673-3091, the statute that Mr. Conklin referenced, both National Residential at the time of the inception of the case and Bank of New York Mellon at the time of trial proved that they had, quote, directly or indirectly acquired ownership of the instrument from a person who was entitled to enforce the instrument when loss of possession occurred. That's what the statute requires, and that's what the two assignments of note proved. And that's what the appellate decisions, including from this court, require, is an unbroken chain of assignments or transfers of the note. That's what we have here. And again, there was no contrary evidence regarding that chain of transfers. There's no case law or legal authority to support reversal. And this one speculative inference based on this unsworn allegation does not provide a basis for reversal. And so unless the court has any further questions, we would ask that the final judgment be affirmed.
Very good. Thank you very much, Mr. Cohen. Mr. Conklin, your rebuttal. Mr. Conklin, you're still muted.
I didn't want any background noise to come in and I forgot.
No, very good.
I apologize. I was going to say, basically, the trial court below ignores the fact that at least for more than a year, a complaint is sitting out there filed by Greenspoon Martyr the attorneys for Bank of America, from whom they have sent the promissory note, and it's in the name of Bank of New York. And so we're to completely ignore the fact that Greenspoon Marta, the very attorneys hired by Bank of America, they send the note to, which then Greenspoon Marta says that, well, we never received it. There's no testimony at trial by the representative from Greenspoon Marta that, oh, we made a mistake. That complaint should have been filed in the name of Bank of America and not Bank of New York. There was no explanation whatsoever as to then, how did this come about that there existed a lawsuit signed by an attorney from Greenspoon Marta stating that Bank of New York was in fact the owner and holder of the promissory note and mortgage and not Bank of America. So basically what happened below then is that the trial court ignored the complaint by saying, well, it's unverified, and I have 2 assignments of mortgage, which I submit are not sworn. As I said, they're notarized and they're recorded, but nonetheless, we're still missing the missing link or even an explanation as to, well, then why was there a lawsuit out there for more than a year filed by very reputable attorneys stating that at the time of loss, it wasn't Bank of America which held and owned the note, but it was Bank of New York. And without an assignment then from Bank of New York to Bank of America, the chain of custody or possession of the note and mortgage is broken, and they were neither able to prove that element subparagraph A of the statute for enforcement and reestablishment of a lost promissory note, and thereby they were also unable to prove standing by the original plaintiff, NRA, National Residential Assets. I would ask that the court reverse the final judgment and enter an order of dismissal. Thank you.
Very good. Thank you both. That concludes